We are honored to have the opportunity to introduce the Repeat Offender Act. I want to thank Attorney General Yost, Sheriff-elect of Clark County, Sheriff of Wood County, and City Council Member Marcus Hanson for joining us today and showing their support for this legislation, which will be a powerful force to protect communities across Ohio. So cities across Ohio have been plagued with violent crime, from armed robberies to drive-by shootings. My home city of Toledo is no different. In 2023 alone, there were over 200 shootings. Our community has watched as the parents of even a 7-month-old child mourn the loss of their little girl who was killed in a drive-by shooting just last year. We witnessed 6 people get shot last year at Smith Park behind one of our libraries, with 2 of the victims being minors, one of which being as young as 4 years old. Yet these aren't just random acts. In fact, the majority of gun crime in Ohio is committed by a handful of repeat offenders who are not allowed to legally possess a firearm. With this legislation, we will continue to fight for the Second Amendment rights of citizens to keep and bear arms while simultaneously removing guns from the hands of violent felons. This bill will get those offenders off the streets by increasing penalties and requiring mandatory prison time for repeat offenders. Without changing a single law that would affect law-abiding gun owners, this bill increases penalties for possession of guns while under disability for violent felons and creates a new firearm specification for using a firearm in the commission of a violent felony when the offender has already been convicted of having a weapon while under disability previously. Currently in Ohio, the penalty for a weapon under disability violation is a felony of the 3rd degree, with a maximum penalty of 36 months in jail. This bill will increase repeat offenses by violent felons to a 2nd-degree felony, where offenders will face a 2 to 8 year prison sentence with a 50% tail, which is under Reagan-Tokes, meaning they will face 3 to 12 years in prison. Additionally, those offenders who have been previously convicted of possessing a weapon while under disability and are convicted of a new violent felony will be eligible for a 3 to 5 year weapon specification, including their mandatory maximum penalty for the underlying felony of a 2nd degree or 3rd degree, facing a potential total sentence of 17 years in prison, in addition to the prison sentence for the actual violent crime. Research conducted by the United States Sentencing Commission supports the strategy of increasing penalties when it comes to repeat offenders. The study concluded that sentences of 60 months or longer had a significant greater deterrent effect than shorter sentences, resulting in 17% decrease in recidivism rates. A comprehensive study of the deterrent effects of gun specifications conducted by the University of Pennsylvania confirmed that gun specifications had a similar deterrent effect on gun crimes. This legislation will give our cities and towns the tools necessary to keep their communities safe and combat the epidemic of violent crimes in our state. In addition, we created a 5-year specification for the discharge of a firearm in the commission of a crime. Under current law, the use of a firearm is only a 3-year specification. We distinguish between the use of a firearm and the discharge of a firearm in the commission of a crime. In addition, we increased the penalties for using a fully automatic weapon or a suppressor in the commission of a crime here in the state of Ohio, where currently you face a 6-year specification for using a fully automatic firearm in our community. Instead, we increased those to 10 years for first offense, 15 for second offenses, and other portions of the bill also. But I'm also going to turn over the podium to my joint sponsor, Representative Willis, who has been instrumental in bringing this legislation forward. We've worked together for almost a year now, going through 7 different drafts, IP meetings, and a lot of sweat and tears to make sure this legislation was going to be introduced today. Thank you.
Thank you, Representative Williams, and thank you all for being here. I'm State Representative Bernie Willis from Springfield, Clark County, District 74, and this is an honor for me to be able to revive something that my predecessor, State Representative Kyle Kaler, had put through as House Bill 383 that did not make it out of the last General Assembly, but the crime did not stop. The deaths by firearms did not stop because of the violent criminals that are doing these things. We came into this knowing that Second Amendment organizations would certainly take a very tight and harsh look at this to make sure that we are doing the right thing. that we are starting with the presupposition that our Second Amendment rights are preserved, and where possible, they can be restored. And so bringing that with an open mind and saying that we didn't have pride in ownership or authorship of this, and that everyone working together would be able to get us to a point where the verbiage said the right things, and where weapons under disability was the focus, and where the crime was not necessarily because of the gun, but it was because of the person who happens to be perpetrating the crime with a gun. And we know that a very small number of people, the governor told us in his State of the State address, a very small number of the criminals are the ones that are perpetrating the majority of the crimes with firearms. This way, and the studies that my joint sponsor mentioned, those things tell us that we can reduce the number of people who will want to do that in the future. We can reduce the number of people that will perpetrate those same kinds of crimes again and get that recidivism rate that we're looking for to go in the correct direction. So I would say at this point we have, and I would also tell anyone, if you want to find a good joint sponsor for something that has legal implications, Josh Williams is the guy. As soon as I said that we were going to try to revive this legislation, he was the first person to call and say, I have really great ideas about how to do this because I do this actively. He is a person that does this in practice and knows the law inside and out. That was very helpful for a person like me that does not have that legal background and certainly needed the extra parts to come together on this in something that I believe is going to be greatly impactful. I think we have great support on both sides of the aisle to get this done because it was really another focal point was the Mayor's Association having sent a letter back in the summer of last year to the governor and saying, we need help. We need a way to figure this out. All of these things come together, I say, in the right direction to get us moving toward getting more people to stop perpetrating these crimes with firearms and stop making the worst part come out in our society. With that, I'm greatly honored to have the Attorney General of the State of Ohio, Dave Yost, here with us. And any comments you'd like to make, sir?
Thanks, sir.
I'm very excited to be here to support this piece of legislation, which has been on my agenda, my to-do list for about the last 2 years. And very excited. Representative Williams is a member of an emerging, exciting emerging class of young conservatives that are thinking about ways to get things done, and this is a great example. I won't repeat everything that's been said about the small number of people that commit most of the crimes with guns, and what has kind of been implied but not said is we need to get these people off the street. You take them off the street, they're not going to be committing additional crimes, and this bill will accomplish that goal. I'm sure that there will be tweaks and healthy debate through the legislative process, but I'm looking forward to something very close to this text to actually being enacted. My side of the aisle regularly talks about law-abiding gun owners. I'm one of them. I know many thousands of them. They are not the problem. The problem are the people that commit crimes with guns, and this bill is surgically targeted toward not gun owners, but actors who use guns for illegal reasons. Just today, we announced the indictment and apprehension of 4 out of 6 people in a human trafficking ring here in Franklin County. The leader of that group, Timotheus Graham, was captured with weapons. He shouldn't have had them. He has a rap sheet longer than your arm, and it was illegal for him to have that. This bill is designed to correct problems like this, to create a penalty. I want you to think with me for a moment about the situation this is designed to correct. We've had multiple rounds of criminal justice reform in Ohio. Some of those things have been very, very good. We have reduced the number of people who don't need to be in a state penal institution, and that's a good thing, I think. Not every crime deserves a lengthy prison sentence. However, the weapons under disability charge, which is a terrible name, it sounds like special needs people with guns. That's not at all what it is. But the idea there is that if you have already committed a felony, you've broken the social contract. We don't want you walking around with a weapon. You have forfeited some of your constitutional rights. Just like you can't vote when you are incarcerated in prison, you have to be released before you can be restored to your citizenship. When you commit a crime, you certainly have the right to remain silent, the right to an attorney, etc. But upon conviction, you lose some rights, including your freedom frequently. So what happens? Somebody's convicted. They either are put on probation or they go to prison, and then they have post-release control. And now, having been convicted by proof beyond a reasonable doubt, told by the judge that they're not allowed to have a gun, they go out and do it anyway, knowing it's a felony. Well, what happens when we catch that person and we arrest him and try him and convict him? We put him back on probation. Most of the cases on weapons under disability under current law result in a renewed term of probation. It's not an enhancement, not a deterrent at all. This is a thing the criminal justice reform got wrong. Representative Williams has proposed a means to correct this. It will make our cities safer. It will take guns off the street that belong to bad guys and not affect the rights of law-abiding citizens. I'm proud to support this bill and hope that the legislature will move it quickly to the governor's desk for signature. Thank you.
Thank you, Attorney General Yost, for your comments. He highlighted one thing that is important to know is that under the current statutory structure, a weapon under disability charge carries up to 36 months, but there's no presumption of imprisonment. The first thing we did in this bill is we said if your underlying disqualification is a violent felony and you are caught with a gun while under disability, it is presumed you go to prison when you're caught for your first offense under weapon under disability. That's a substantial change from what we have now, where we see the majority of cases getting placed right back on probation, even though they knowingly were in illegal possession of a firearm, and we may even have apprehended them on their way to commit a violent felony, and we just got them before they were able to commit that crime. So that was the first starting point, and then from there, we looked to expand every avenue of our statutory structure to increase penalties that we thought could help prevent violent crimes in the future. I appreciate you guys being here. I appreciate my joint sponsor and all the hard work he did, and we will open it up for questions at this time.
Representative Willis, you mentioned Kyle Taylor before. Why is this time different?
I think the bill that was introduced before was done so in good faith. At a very short period where it was going to be able to get through the GA, and that caused just a compression of how much would be able to be done. As my joint sponsor stated, this is on its 7th version already, and it definitely takes I would say an intent amount of time to spend with each of those organizations to make sure that they have gotten their voice heard, that they have gotten the pieces and parts that make it align with what they believe is going to get good legislation through. And that has led us to having a good partnership on this bill. The one thing that I would also add to that is when we're dealing with things like any legislation that has a weapons content with it, the Second Amendment organizations, and I've told them from the beginning, I'm one of the staunchest advocates for the Second Amendment. And so we wanted to make sure that we did that right. And so I greatly appreciate the fact when I approached this with Josh, Representative Williams, that he had great ideas on how to also make things match up and how we could get to the point where people were in agreement that we were doing the right things and focusing on the actual bad actors, not necessarily focusing on the actual weapons, but the fact that people continually are doing these crimes with weapons, and the only way to get that to stop is to start elevating the standard. One of the other things I would say is we don't want to be where Tennessee was, like within the last month, right? Memphis has An 18-year-old who shoots a police officer and kills them after having been just a month prior with a felony auto theft, taken into custody with a full automatic weapon and was released with no bail, right? And a month later kills a police officer. Could that happen in Ohio right now, the way our structure is? I believe it's a possibility. I don't want to be the state that says, yeah, we saw that happen and didn't fix it.
Hold on, if I can add to that. So the bill that Kaler introduced is substantially different from ours. So that bill started off with the premise of raising all weapon under disability charges to a felony of the second degree. And that was not the right approach. Our Second Amendment groups were not in support of that because it increased penalties for all individuals that are caught. Some of them may have had a minor drug felony, a F5, when they were 18 years old. I've had clients myself, one out of Sandusky County. He had a conviction from 1996. At the time of the conviction, his felony was non-syllable. 20 years later, we've changed the statutory structure in Ohio. He's eligible to have his record so he never knew. He got into an incident where his buddy was being stabbed to death. He retrieved his wife's gun and discharged it in the air. The crowd dispersed. He ran to render aid, and he got sentenced to 17 months for that first weapon under disability because that felony never got off of his record. So the difference in this bill is not only did we want to increase penalties, but guide those penalties towards the violent offenders. So the underlying disqualification has to be a violent felony in order to get these increased penalties that are currently proposed. In addition, we increase the specifications. Specifications mean it's the use of the gun in the commission of a crime that warrants the specification. I'll give you some examples. A drive-by shooting, 5-year specification currently. Our bill increases it to 7 years. The discharge of the firearm is a new 5-year specification. The use of fully automatics. We have statistics in front of us that shows the rate in 2016 in Ohio, there was 494 criminal incidents with automatic weapons in the state of Ohio. I've personally been on cases where I could tell from the evidence that gun was fully automatic, but it was never tested. I can tell those type of stories over and over again as a practicing criminal defense attorney. So the first premise was to be able to create a balancing here of not only increased penalties for violent offenders and repeat offenders, but also include some criminal justice reform that some of the gun organizations wanted. Like, for example, in current statutory structure, if someone lives outside of the state of Ohio and they have a felony on their record that is non-sillable, when you sill a felony, your Second Amendment rights are automatically restored unless the judge withholds them. If you have a felony that's non-sillable on your record, you can apply for your Second Amendment rights to be restored in the state of Ohio. But if you live outside the state, the current statute says you have to apply in the county in which you reside. So I have clients from Michigan, Florida, New York that lived in Ohio at a period of time and had a felony that's on their record, and now they can't apply to get their firearms rights restored because they're not a resident. We fixed that in this bill as well. It says you have to be either where you're a resident or where the actual sentence was rendered in the county. So that was one of the fixes that we've also done that in another bill that hasn't made it to the floor. That's one of the fixes that some of our gun groups wanted, because it's a reasonable hole that we need to fix in our statutory structure. So that's how we were able to come to a balanced bill to where we can proudly say we've worked for several months with Buckeye Firearms, who's a proponent of this bill, with Ohio Gun Owners Association, who's neutral in the bill. We've worked with all interested parties involved to try to come to the best bill possible where we can attack gun violence in the state of Ohio and at the same time preserve and enhance Second Amendment rights of law-abiding citizens.
Bill, this is the 7th version that's formally being introduced, but there is only a quarter left. The GA had to talk with both House and Senate leadership about whether this legislation will be a priority.
Well, we have. We've spoken to the Speaker. The Speaker's office has been informed of every installation that we've had. We've also reached out to Senator McCulley over in the Senate side and worked with him on the first draft, and that portion has stayed in. There's sections that he was considering introducing a bill on some gun reform, and we were able to kind of morph it together. And it took a while, not because we want to rush bad legislation through, but because literally we were at the table with interested parties up until last week, making sure we draft this bill, because part of the problem with Kaler's bill was the introduced version was so substantial of an increase in penalty, the Second Amendment groups could never get behind it, even though he made modifications through the committee process. They could never get behind it. So we took pride in saying the introduced version that we're going to introduce today is a version that can carry all the way through committee without substantial changes and be able to make it to the floor and pass and hopefully make it to the governor's desk.
You talk about enhanced penalties and all that's well and good for a legislature to propose, pass, governor sign. Obviously, there's another player in this. We have judges, and many critics say you can make the law as tough as you want until a judge starts cracking down with the sentences that are available to him or her. It's not going to work. Is there anything you could do in the law to change that?
Sure, I appreciate the question. That's why in our specification and repeat offender spec, we took the discretion of judges out of it, just like the repeat violent offender spec. It's a mandatory sentence. So ours says that you must give the maximum mandatory penalty allowed under the statute. So if it's a felony 2, that's 2 to 8 years, you shall give that person 8 years. Then the discretion is whether or not the specification is a 3-year, a 4-year, or a 5-year specification on top of that 8 years. So with Reagan Tokes, we're talking an 8-year sentence will be 8 to 12 for bad behavior, and in addition, up to a 5-year spec. So in theory, if you're a repeat offender, a violent offender, and our spec concentrates on the use of the gun in a violent offense, not just possession, but the actual use, the brandishing of it, the threatening of the use of it, the discharge of it. That's where the specification kicks in and bridges a gap between first-time offenders and repeat violent offenders where there has to be 2 prior violent offenses in order to get that specification eligibility.
As you well know, judges don't like having their hands tied, and they can reduce charges, or they can put people on probation, perhaps despite them. I mean, is there any way you can nail this door absolutely shut?
I appreciate the question. There's no way we can ever. We give discretion to our judges. We respect the judicial branch. I'm a constitutional law professor. I believe in 3 co-equal branches. What we can do is draft legislation that shows clear legislative intent to judges. We can draft sentencing guidelines that show what we want to be done. And in some instances, we can tie the hand of judges by saying you must give the maximum. But at the same time, we gave some discretion. A lot of times what happens in gun crime cases is not the judge, because the judge doesn't have the authority to just reduce the charge. The judge makes a decision once there's either a plea agreement or there's a guilty verdict on what charges are rendered. It's actually the prosecutor's office who decides, one, they have to include this specification in the indictment, just like RVO, the MDO spec. You have to include it in the indictment in order to be able to process it through and get it to final resolution. And those are some of the first things that are negotiated away in plea bargaining, is removing these mandatory specifications. We need prosecutors in all 88 counties to really consider gun crime a serious problem in our state. And what's going to happen is we're giving you stronger and stronger tools to use in your community to combat gun violence. And if your local prosecutor, your county prosecutor elects not to do it, they need to be called to task by the voters in that district. That's what the voting process is for. That's what our system is made for, that the local voters can decide on if a prosecuting office is being too soft on gun crimes, because we're giving them every tool we can think of to put these repeat offenders behind bars for decades.
If this is enacted, do you think there's a need for further gun legislation, or do you think this is kind of the fix-all to help fix the issue of gun violence across the state?
This will become part of the Ohio Revised Code. And so I don't think we could ever be able to say that we would be done. What I think this does, though, is it addresses a very, very hard problem. We have had entirely too much crime being perpetrated by people who are doing it again and again. This is an elevation of that, to recognize the fact that that small number of people, and it's just, we have to realize that it is a very small number of people that are continuing to perpetrate these crimes. When this is hopefully signed into law, it will again be part of the Ohio Revised Code, and is always up for revision. We are undoubtedly going to have other things that are going to pop up as the highlighted item that becomes hopefully something different, but what the next perpetrator decides that they're going to do, that we will undoubtedly have to deal with. So I would never say that we are closing the door on firearm legislation or something that helps us in this way. but it is certainly a huge step forward, I believe.
And I believe there's no silver bullet to fix these issues. This is just a piece in the puzzle. But we reject the premise that firearms alone are the problem in our community. I mean, we saw that according to a report published by the Center of Justice Research, which was initiated by the Ohio Attorney General's office in Bowling Green State University, where gun violence decreased after constitutional carry was enacted here in the state of Ohio. I mean, Akron, Columbus, and my hometown of Toledo have experienced substantial decreases in overall gun violence, and rates of gun crime in Parma fell 22%. I mean, this study's been out for a while now. It has its own critics, but I mean, there's been some anecdotal evidence that it's not just the guns themselves that are the problem. It's the guns in the hands of the wrong people that are the problem. These repeat offenders, people that have been told by judges at sentencing, you shall never own a gun or ammunition again in your life unless your rights are restored. And some of them get out within 6 months. They're caught doing another crime. I've had it happen. I've defended individuals I've had individuals that were in jail for 10 years for felonious assault. Within 6 months, came out and was accused of a murder, and eventually pled out to a charge and was sentenced to a long time behind bars. That's a repeat offender. Then I've had other offenders that get caught 2 and 3 times with firearms, and I was able to get the judge to look at the root cause of why that individual had a gun. And that was PTSD and violence that had occurred in his community. And we were able to get him substance abuse and mental health counseling, effectively cutting down on his risk of recidivism. There are opportunities for prosecutors to make decisions, to use their discretion. There's opportunities for judges to make their discretion, to use their discretion. But there's also opportunities for legislators to step up to the plate where other people have been unsuccessful in bringing meaningful reform to the state of Ohio. And I believe myself and Representative Withers, what I will say, the co-sponsor request came out from him that he was going to introduce that bill. And I reached out to him and said, hey, I've also got something I've been drafting. Let's sit down together and see if we can get one bill where we can get everybody on board. And he said, man, if you could get the gun associations on board, along with some of our criminal organizations and individuals like Attorney General Yost on board, it would be a godsend for Ohio, because that's something that could actively make an impact in our community. I'm tired of turning on the news in Toledo and seeing 4- and 6-year-olds die in my community from stray bullets. I'm tired of turning on the news and knowing that there was a 4th of July block party in my community where over 80 rounds from AR-15s and AK-47s were fired. And 3 years later, I represented a young man who was shot in his abdomen and got caught carrying a gun twice in 6 months because he's so apprehensive about guns in his community that he doesn't care what we tell him that he can't carry a gun. He was always going to carry one until we got him mental health treatment and broke the cycle. So I'm tired of looking at those reports on the news, knowing that I'm in a position to make change. So I'm going to introduce this bill and any other bill that I think could meaningfully have an impact on violent crimes in Ohio without demonizing legal gun owners.
My question, Attorney General. Inquiry. As you know, I mean, you've been a statewide officer for a long time. This philosophy of this proposal has been around a long time, and it's gone down in flames a long time. Is what you're hearing today from the sponsors convince you that this may be the one that actually is going to become law and address the gun violence problem in this state?
So first of all, this is a new proposal. This hasn't been bouncing around. Representative Williams has engaged in some stakeholder negotiations with the Second Amendment stakeholders, and this represents a new take, a different kind of balancing. And yes, I'm actually kind of hopeful and optimistic that this bill might move forward because it doesn't target law-abiding gun owners. It targets criminals who use guns. I will say there's when you talk about velocity, there are different levels of velocity for different sessions of the General Assembly. But I'm confident that if this does not make it through this time, it won't be because of the bill. It will be because of dynamics inherent to the current session. And I'm sure it will come back next year and move quickly.
You talked a lot about the coalition behind this. Have you heard from the prosecutors, or do you have any Democratic co-sponsors in the bill?
So I believe we have currently one Democrat co-sponsor. The Prosecutors Association are going to be in opposition to the bill because of one provision that they don't like. We're still at the table having discussions. We've kept them informed at every iteration of the bill. There's support behind a substantial portion of the bill, but there's a small portion of the bill that they don't like, and that was enough to get them to a opposition position.
What is that?
Automatic sealing of F4, F5s moving forward prospectively. What that would do is, what we're talking about is F4, F5s, 5 years after you become eligible to have your record sealed. For 5 years, you can apply to get your record sealed. After 5 years, there would be an automatic process, similar to some of our surrounding states, for automatic sealing if you have an F4, F5 with no other felony convictions. So we're talking first-time offenders who haven't reoffended, completed 5 years with no recidivism. That is a portion that was requested. And the prosecutors are in opposition to that because they hate the idea of sealing individuals' records. But when we pay our debt to society, we understand time and time again there's collateral sanctions associated with a felony conviction on your record. Everything from employment to housing to whether or not you get allocated child custody in a divorce. These are things that are real for individuals with felonies on the record. So when you've committed a felony, we're either going to tell people you're going to be punished and always a felon, or we believe in the idea that you can be rehabilitated. And those individuals who have been rehabilitated should have an opportunity to get their record sealed moving forward. And it shouldn't be just those individuals that, one, know that they can have their record sealed, two, can afford to hire an attorney like me to articulate for the records to be sealed, or individuals who may not be aware of the process that's in play. We want to make that a provision that it should be automatic for first-time offenders moving forward, and that's a portion of the bill. That we do get some opposition to that portion of the bill. All eligible F4s and F5s that are currently sealable. So that we're talking non-violence, we're talking non-sexually motivated, we're talking about F4, F5s that currently are eligible to be sealed under current law, given the same requirements. And we comply with Marcy's law because it says essentially at a certain point the court will make parties aware that they're eligible for the record to be sealed. The prosecutor and the victim, if there's a victim in the case, will have the opportunity to object. And if there is an objection, there will be an actual hearing held. The difference is now the defendant doesn't have to seek out that hearing, doesn't have to pay a filing fee, which has now gone up in some jurisdictions to over $100. Some jurisdictions up to a maximum of $175. And it makes a smoother process for individuals.
Can you talk about some of the responses you got from law enforcement officers throughout the state?
Well, we have two, a sheriff-elect and another sheriff here presently. We've talked to some of our other police chiefs across the state. They're looking for any legislation to cut down on gun violence moving forward. So I really appreciate Attorney General Yost coming. I appreciate Sheriff-elect, Sheriff from Wood County, which is my new district. And I especially appreciate one of my city council members for taking the drive down here to support this legislation moving forward. And we hope we can get it to the floor steadfast. Thank you.